who will be doing Spanish translation. You can see the translation button at the bottom of your screen if you would like to participate in that. Are we ready? Okay,
And yeah,
let's start.
So the interpretation button is at the bottom there. Should
Yeah.
be English and Spanish. And then if on the Spanish channel, I believe Irene is explaining that right now.
Okay.
Okay.
So, hi, everyone, and welcome. My name is Julie Anderson. I am the Outreach Director at Restore Justice. I care about this work and became involved in the work because my son was sentenced to life without parole in 1995 when he was 15 years old. In 2008, I was able to participate in and start a family group, a family support group. Up until that time, really kind of didn't have anyone to turn to. It was a very lonely and isolating time. 6 years ago, Restore Justice came into being. Restore Justice, we work on reducing long-term sentences for younger people. And we consider 20 years long-term. We consider life to be 40 years. And we also work on current conditions inside prison, trying to change laws. We have been holding legislative trainings for loved ones and advocates since we began, which was in 2015. This past June, we were able to help pass a law that established a family liaison in the IDOC. We do hope to build on this reform. So maybe we'll be able to take some of you along with us to help us build on that. I just want to say grievances are the start of trying to address any problems within the IDOC. And I am so grateful to our speakers, Alan Mills, Pablo Mendoza, and Marshawn Allen. They're extremely qualified to speak on this issue. And I am sure we're all going to gain a lot of knowledge in the next hour. And I want to thank them for joining us.
Hi, everyone. Thank you for joining us this evening. My name is Chrissula Grievance, and I'm a member of the Coalition to Decarcerate Illinois. My loved one has been incarcerated for the last 18 years, and a big reason why I'm involved in this work. Originally named the End Illinois Prison Lockdown Coalition, we formed in direct response to the IDOC, Illinois Department of Corrections, failed policies to stop the spread of COVID-19 in its prisons. The Coalition to Decarcerate Illinois is a group of loved ones of the incarcerated, currently and formerly incarcerated individuals, activists, and creatives working towards abolition and fighting for the rights and dignity of currently incarcerated individuals and their loved ones. This summer, we launched our Loved Ones training series for political education and advocacy. We are really pleased tonight to be continuing that work with Restore Justice, one of our coalition members. We have three wonderful panelists, as Julie mentioned. We will start with Alan Mills, and I will give you a little bit of background on Alan. Alan is the executive director of Uptown People's Law Center, a nonprofit community legal clinic located on the north side of Chicago. UPLC is a legal organization that fights for justice for tenants, the disabled, and prisoners in Illinois. He began as a volunteer law student at UPLC in 1979. Alan has tried dozens of individual cases on behalf of prisoners in state and federal court during the last 40 years. UPLC is currently lead counsel in 5 class action cases alleging that Illinois prisons violate the constitutional rights of Illinois prisoners. These include claims that the medical and mental health care provided to prisoners violates the 8th Amendment prohibition against cruel and unusual treatment, the state's failure to accommodate the communication needs of deaf and hard of hearing prisoners, a claim that hundreds of guards used excessive force during a series of shakedowns, and a case challenging the excessive use of segregation in Illinois prisons. Alan graduated from Northwestern University School of Law in 1981. Since 2005, he has served as an adjunct professor there, teaching a seminar on prisons and prisoners' rights. For the last 10 years, he has also helped train attorneys appointed to represent prisoners in civil rights cases by the U.S. District Courts for the Northern and Southern Districts of Illinois. Welcome, Alan.
Good evening, everybody. Thank you for joining us tonight. My job tonight is to sort of lay out the legal framework for grievances and why they matter, and a little bit about how they're not used. Since I have never, thankfully, been in prison, I'm not going to talk about what it looks like from a prisoner's side, but we've got two excellent panelists who know that inside out, unfortunately. I have a little screen share, which I have a PowerPoint, which I'm going to hopefully manage to share with everybody. There we go. I think we're up. And why isn't it moving? There we go. So in a good system, a grievance process should be used by the administration in order to identify problems, identify problem officers, and identify problem parts of the prisons, identify problem programs so that they can be addressed. That is not what the Illinois system does. Illinois system is generally designed to deny grievances. And I'll talk about more of that later. But if it's not going to do any good for prisoners, then why do we care? Why shouldn't everybody just ignore it? And that's really what I want to talk about. And the main reason is because the Prison Litigation Reform Act, an act passed under Bill Clinton back in the 1980s, said that if you ever want to bring a case to federal court, if your rights are violated in prison, and you ever want to go to federal court about that, then you have to file a grievance. Not only file a grievance, but also continue it all the way through all possible appeals. It's a very broad statute, and it applies to lots and lots of situations. It talks on its face about prison conditions, but you'll see it's much broader than that. So when you say no action may be brought, that's the first part of the statute. What that means is you have to have exhausted your entire appeal process before you file the lawsuit. It's not good enough to say, well, the day after I filed, they denied it, so you should let it slide. It has to be denied before your case is filed. Prison conditions. Well, you would think that would be things like the cells are too hot, the cells are too cold, there's water leaking, my water is undrinkable, the food is terrible. All those are conditions as most people know it. But in the Prison Litigation Reform Act, the Supreme Court has said that conditions has a much broader view. It covers anything that happens inside prison. Basically, if the grievance process has the ability to do something about the general subject matter, even if it can't do anything for you, then it's counted as a prison condition. So you have to bring it no matter what happens to you inside prison. There are a couple of narrow exceptions in Illinois, but in general, anything that happens to you in prison, if you want to take it to federal court, you've got to exhaust the administrative process first. By a prisoner, it means anybody who's detained, and whether it's in a jail, whether it's in a prison, whether you're waiting for trial, whether you've already been convicted, it does not count for people who are on parole or on probation, but it does count even if you're back again on a parole violation, you're still in prison. So it's a question of where you are physically located at the time that the wrongful where you're physically located the day you file the lawsuit. So even if what you're talking about happened in prison, if you get out of prison, you can file the lawsuit after you get out, even if you never filed a grievance, as long as you get out soon enough. So some people just want to wait and file their lawsuit after they're out and not worry about the whole grievance process. But that only works if you're going to be out soon. You only have to exhaust the ones that are available. On the other hand, you have to use the forms that are used by the prison. You can't just write a letter. You have to use it. You have to meet the deadlines that are established by the prison rules. And you have to use whatever kind of specificity the rules say you have to use. So if it says you got to give the name and address of the person you're filing a grievance against, then you have to do that if you can. And if you don't complete the process, then your federal claims may be barred forever. So this is not something you can just skip over, and if the court catches it, start over again. By that time, it'll be too late, and you may never be able to bring your case to court, no matter how meritorious it is, no matter how much you would win the case otherwise, you're out the door. Exhausted means a final ruling from the highest level in the system, so you don't have to file a state court case first. But you do have to appeal. You can't just take it, well, the counselor said no, or the grievance officer said no, or the warden said no. You got to take it all the way up to the highest level of whatever system you're in. I'm going to go through that process for the Illinois Department of Corrections, the prison system. But every system has its own grievance process. It's not going to be the same elsewhere. If you're in federal prison, there's a similar process, but the steps are a little different. If you're in the Cook County Jail, they have their own process, but again, the steps are different. And if you're in any of the other 101 counties in Illinois, each one of them has its own grievance process. I believe there are only 1 or 2 of those 102 counties in Illinois which don't have a grievance process at all. If it doesn't exist, you don't have to use it, obviously. But if it does exist, you got to follow their individual rules and take whatever appeals those systems provide for within the rules. So it's important to look at those rules and make sure that you've had it or your loved one has gotten those rules and follows them to the letter. Otherwise, their great case may be thrown out and never get to court. All right, so most grievances have to go through a multi-step process. It starts, of course, with the prisoner. Something bad happens to the prisoner. The prisoner has to file with the grievance itself on a grievance form, and I'll show you one later, with their counselor. If they don't get all of the relief they want from the counselor, they have to go to the next step, which is to file a formal grievance with the grievance officer. The grievance officer does not give a response to the prisoner. A grievance officer simply passes on their recommendation to the warden. The warden then rules on the grievance, and 90% of the time they do whatever the 99% of the time they do whatever the grievance officer recommends. And in fact, you should be aware wardens themselves don't actually look at grievances in 99% of the cases. It'll be somebody that they've delegated it to. Maybe their administrative assistant. It may be the director of the assistant warden for operations. It may be somebody else in the prison system. Wardens are allowed to delegate that review to somebody else by the Illinois Department of Corrections rules. The warden's response then goes back to the prisoner. If the prisoner is satisfied, great. If they've ruled on all, if they've given you all the relief you want, great. If they have not given you all of the relief you asked for, then you can appeal that and have to appeal it to the Administrative Review Board, which is a body that sits in Springfield. Its address is at the bottom of each one of the grievance forms. The Administrative Review Board also does not give its response back to the prisoner. Instead, it makes a recommendation to the director, and then the director makes the final ruling. So you haven't exhausted the entire administrative process until you get a letter back from the director saying, I've considered your grievance and either I've granted it or I've denied it. So you want that golden letter from the director. There are a few narrow cases where you can skip some of those steps, most of those steps, and those are 3. One, if you are trying to get into protective custody and you're denied it by whoever it is who makes that decision in the prison, then you can appeal that directly to Springfield, and that goes to the director immediately, and then there's a ruling usually within a very short period of time. So that can be skipped over. All those steps, going to your counselor, going to the grievance officer, going to the warden, all that's skipped for protective custody. Similarly, if you are being told you have to take a psychiatric drug and you want to refuse that, then again, that appeal can go directly to Springfield. It does not have to go through the process in the prison. The reason for that being that taking psychotropic drugs, if you're not actually mentally ill, is a severe restriction on your rights. And the Department of Corrections has agreed you can jump the line and go right to the front, right to the end of the process for that. The final one is if what you're complaining about happened at a different prison of the one you're at, then you don't have to file a grievance either at the old prison or your new prison. You can go again directly to Springfield. So for example, if you were beat up at Menard, and the first thing they do is transfer you to Pontiac. So you're at Pontiac and you haven't filed a grievance yet. You don't have to file it with either Pontiac or Menard. You can file directly at Springfield. So again, that's a quick way to escape many of the individual steps that take forever. So speaking of taking forever, deadlines here are crucial. And as with many things in the Department of Corrections, they are not in any way the same for prisoners as they are for staff. So prisoners have a short time frame. They have to file their grievance within 60 days. Get up, beat up by a guard, you have 60 days to file that grievance. If you don't file the counselor in 60 days, you can be barred forever from bringing a grievance and therefore from going to court. So that first deadline is important. The counselor, however, has no deadline to get back to you. There is another problem here, which is the grievance officer. The deadline there is that exact same 60 days, but you can't file the grievance officer until you get a response from the counselor. Remember, the counselor doesn't have a deadline. So often you'll be faced with a situation where you don't have a response from the counselor yet. The 60 days is about up. You have to file the grievance officer without the counselor's response, and the grievance officer is likely to kick it back down again and say you improperly filed it because you don't have a response from the counselor. So there's a catch-22 built right into the regulations. There's no way to comply with both of those rules. We always recommend that people file the grievance officer, and if they send it back again, great, file a second time as soon as you get that response from the counselor, but at least you tried. How long does the grievance officer have to respond? There's no deadline. It's supposed to be 60 days, but then there's wiggle room where reasonably feasible under the circumstances. What does that mean? That means if they have a lot to do, then they don't have to do it within 60 days. Is there an outside limit? No, there is not. Not in the prison system, and not in the Illinois system. In the federal system, it's better. The federal system says that if you don't get a response within the time frame that's set out, then you can assume it's denied and appeal to the next level. There is no such rule in Illinois. So you are supposed to sit around and wait forever for a response. Once you get that response from the grievance officer or really the warden, but it's really the grievance officer's response, then you have 30 days to file. What often happens is the warden signs it on one day, but you don't actually get a copy for several weeks. So don't sit on it. It's not from the day that you actually get it. It's the date that the warden signed on it. So as soon as you get that response, you got to send it off to the warden. No time limit for the director to make a decision either. Again, it's within 6 months after receipt, where reasonably feasible under the circumstances. Meaning if they've got other things to do, they don't have to answer on time. So again, there's no deadline by which they have to respond. That puts prisoners in a very difficult situation. How long do you have to wait before you can file? You can sit there and wait 6 months. They haven't responded. Some people jump right into court, in which case the Department of Corrections will clearly argue in court that you filed too soon because you hadn't exhausted all your grievances. We at the Uptown People's Law Center did a case where we waited something like a year, at which point we filed saying it was hopeless. And the Department of Corrections filed a motion that we had two motions. The first one said we filed too soon because we never got a final response to our grievance. The second one said we waited too long because we should have known it was denied already and should have filed way before we did. So again, there's a catch-22 there. Again, we recommend everybody just file shortly after that 6 months because otherwise the department's going to argue you waited too late. If you get thrown out, then you file again whenever the director does make its decision, but at least you try. So what happens if you never get a response from the Department of Corrections? Can they simply keep you out of court by never responding to grievances? No, that is what the statute says, but no, you can't. The Seventh Circuit and the United States Supreme Court has made it clear that if they don't answer grievances, then the grievance process is not available. Remember, you only had to exhaust those administrative remedies which were, quote, available. If they don't answer, then it's not available. Similarly, if they stop you from getting pencil and paper, if they don't give you the forms, there's a case where a man was in a coma and they tried to argue that he should have filed a grievance. Well, he's in a coma. He can't do that. It's not available to him because he's in a coma. So there are lots of arguments you can make if you haven't exhausted your administrative remedies. Don't give up. There's ways around it, but in general, you got to file that grievance. You got to finish that whole process. Next, I want to talk about a couple of things that don't count as grievances. Every inmate has an inmate request form, a resident request form. That can be used for anything. And sometimes they sound a lot like grievances. If, for example, you want a religious diet, which is what this case was about. You send off a request form to the chaplain, and the chaplain says, no, I'm not going to give you a religious diet because I don't think you're sincere, or whatever the reason it may be. And you may think, all right, well, I've exhausted my remedies. The chaplain's the one who gets to make those decisions. He said no, so I'm good to go. Well, no, that does not count as a grievance. That's a request form, not a grievance. In the Cook County Jail, you'll often see that prison officials will cross out the part. There's the same form as using county jail for requests and for grievances. So you often see that in the county jail, that the prison officials or the jail officials will cross out the part that said grievance and categorize it as just a request. And then even though you've gone through the same form, they will argue you haven't finished the process because all you did was file a request, not a grievance. Similarly, sometimes you may get a nice type official letter back. In this case, it's a response to the same thing about the religious diet, saying absolutely not, and giving all the reasons for it, and saying he's not going to do it. That looks like it's a final response, but it's only from the chaplain. It's not from the director, so it doesn't count as exhausting a grievance. So what does a grievance form look like? Well, this is an actual grievance. So in this case, Mr. Nelson did not give up after filing that inmate request and after getting that letter back. He knew better than that. So he filed a formal grievance after the chaplain came back and said, no, I'm not going to give it to you. Laid out exactly what they're doing wrong in his handwritten request. One of the issues that comes up a lot is how do you get a copy of this? Well, they banned carbon paper in the Department of Corrections, so you can't get carbon paper. You can, in theory, send it off to the law library, but unfortunately, things disappear in the law library when you ask for copies way too often. And of course, you have these tight deadlines, and the fact that the law library took too long to make your copies is not an excuse for not filing on time. So we just recommend that everybody make a second handwritten copy. Some people send it out to their family members to make copies. If you get such a thing, you should make sure you copy it and send it back right away. Don't sit on it because that clock is ticking. We always recommend that people not do that because God only knows how long something will sit in the mail before it gets delivered. I always say, great, do that, but do that with a second copy that you made. Send the original in right away. You want to get a second copy back, great, you can get the second copy back. All right, so I talked about what happens when the counselor's response. Well, this is what a counselor's response looks like. In this case, all they did was quote the letter that we talked about before from the chaplain saying, no, we're not going to give you a religious diet, end of story. So that's often what happens is the counselor will simply call up whoever made the decision in the first place and say, did you mean what you said when you said you weren't going to do it? And in this case, the chaplain wrote back and said, yep, I meant what I said. I'm not going to give it to him. So that's the counselor's response. They already said no. So what are you talking about? Counselors are unlikely to resolve most grievances at all. And then it goes to the grievance officer. He did appeal, went to the grievance officer. Grievance officer goes through the facts, and then makes a recommendation to the warden. And then the warden at the bottom of that form signs off and says either I concur with the grievance officer's recommendation, I don't concur, or send it back for more information. Again, as I said, in 90+% of the cases, the warden is just going to check that box saying I concur. And again, you notice here it says George Wellborn, who was in fact the warden at TAMS when this grievance was filed. But in fact, you notice afterwards there are these initials, CSD. That was his administrative assistant, is the one who actually reviewed this grievance and denied it. The warden never looked at it. George Wellborn probably had no idea this even happened. So this time, at this point, then Brian did want to appeal. So he filled out this bottom part of the grievance. And notice he did it easily within that 30 days it's required between May 30th and June 11th is when he filed. Sent it off to the address that it says here at Springfield to the Administrative Review Board. Sent it off on June 11th. And 6 months later, on December 16th, he gets that final letter, which has a signature by the Administrative Review Board and the final signature by then Donnie Snyder, the then director of the Illinois Department of Corrections. Again, notice that there is a initials afterwards, meaning Don Snyder is not the one who actually looked at it. Somebody else looked at it and agreed it. It's usually just another member of the Administrative Review Board. So you just have two people on the Administrative Review Board who are making the same determination, and the chances of them disagreeing with each other is pretty small. Okay, so this process, as you can imagine, can be a little bit frustrating, to say the least. Lots and lots of prisoners give up and don't bother to do the grievance process because they always say, well, nobody wins grievances. What's the point? As I said, you got to do it. It's not an excuse that you know it's going to be denied. It's not an excuse that 20 other guys on my unit filed a grievance about the exact same thing and every one of them was denied. That does not give you a reason not to do it. It doesn't matter that the warden has made a public announcement saying, I'm going to deny these. Don't bother to file grievances, which has happened. And we've actually had wardens who sent around a memo saying, don't file a grievance on this. It's because they're all going to get denied. Well, ignore that advice. and file anyway, even as frustrating it is. And as much as you want to give up on it, as much as you just want to tear up all those forms and say it's totally useless, don't do that. If you ever want to get to federal court, you can't just tear them up and ignore the process because it's frustrating. You got to go through with it. So, take a deep breath, do a few push-ups, whatever you do to calm down, and then file your grievance. And I want to give you an example of just how infuriating this process can be. So this is a man at Stateville. They did a shakedown of the entire cell house, moved everybody out of the cell house, took them to the dining hall where they all sat around while the guards were shaking down their cell when they were not present. So they didn't see who did what. He came back to his cell and discovered that a whole bunch of his stuff was gone. And he had no idea what happened to it, but he says, they were the only ones there. I wasn't there. They took me off to the dining hall. So I don't know exactly what happened, but all my stuff's missing. So I want money. I want you to pay me back for all the materials that were lost. Attached to this grievance were a copy of his commissary slip, a copy of the shakedown slip. So he could prove that he actually bought all this stuff and that they had not officially confiscated it during the shakedown. His theory is, as all too often happens during these shakedowns, that they simply destroyed it. Well, the counselor didn't, and notice that there is a way to track these grievances. That's why I circled this little part here. For many years, there was not, but now you get a tracking number when you file a grievance. So you notice here, this one's given number 1028. The counselor should assign a number right away, so at least you have a copy of that number, even if you don't have a response to your grievance. So at least you can prove that it was filed, that you did get something. And that gives you a way to track it through that whole system. You should keep that same number all the way through the director. So if you want to find out about a grievance, you no longer have to remember what date it was filed on, or have a copy of it. If you have that tracking number, then you should be able to use that to figure out what happened to your grievance. And it proves you filed it, because you wouldn't get a tracking number all by yourself. Only the counselor can give that to you. Well, speaking of the counselor, in this particular case, it's a really unusual grievance, because this counselor says, I was there during this shakedown and I saw them throw away his stuff. Yes, he should get money back for this. That is not usual. The vast majority of cases, the counselor says, yes, it should be denied. And they almost never will say, yes, you should give them money. And they will almost never say, yes, I was there and actually saw it. So yes, you should definitely give them money. This is golden. This is like what you hope will happen in a grievance process. This is what the grievance process is supposed to do, identify problems. But of course, the counselor doesn't have any power to actually give him any money for this. So he has to appeal. So he does appeal, and it goes to the grievance officer. And the grievance officer starts off fine, saying, counselor responded. I was there, they threw it away. He should get money. Just what the grievance officer is supposed to do, accurately report what the counselor said. So there's a statement right by the grievance officer's thing saying, we have a witness who said this is exactly what happened. But then in the very next paragraph, the grievance officer says, there is no evidence. Despite the fact that one paragraph before it, she cited the evidence. So all of a sudden it goes from, I have an eyewitness who backs me up, to there's no evidence whatsoever to support this. And of course, the warden went ahead and just confirmed, said, yes, we're not going to give him any money. So now he's stuck with, and he's appealed to the ARB, and they said the same thing, despite the fact that it says right in the grievance that they have a witness. They all say not entitled to your money. So now he has to go to federal court or to court of claims or somewhere to try to get compensation for his belongings. That's the kind of thing that you see all too often in the Department of Corrections, where the grievance officer is only looking for a reason to deny it, no matter how good your grievance is, no matter what evidence you submit. And you can understand why guys get frustrated. And believe me, they do. But even as stupid as this is, you've just got to go through the process. And that's where I turn it over to the people who have actually gone through this process to talk to us about what that feels like.
Thank you so much, Alan. That was a very useful information. Much appreciated. Our next panelist is Pablo Mendoza. A little about Pablo. He's a proud father and lifelong learner. He's been directly impacted by the criminal justice system and served 22 years in the Illinois Department of Corrections. He strives to pave an easier path for others that are currently and formerly incarcerated. Pablo is working to close the valve of the school to prison pipeline. In doing so, he's in constant conflict with the privileges that this society instills upon him and resists them, hoping to build a new tomorrow founded upon acceptance and non-judgment. Pablo wrote many grievances while incarcerated in the Illinois Department of Corrections and is currently working for the Prison Neighborhood Arts Project as a project manager and research fellow. Welcome, Pablo.
Thank you very much, Crisula. And thank you everybody for joining in. Alan brought out a lot of good points of how ridiculous the grievance process is, but unfortunately it's a process that's necessary according to the courts. So he brought out, I didn't have access to actual grievance because those kind of actually stay inside, but he presented a grievance in and of itself, and it had a nice letterhead on it. I'm gonna go over certain things that you have to have within the grievance. The body of the grievance, one of the major things is to have your name. Now, when we're talking about fighting the grievance, we're assuming literacy. That's an assumption that I don't like to put forth. That's a privilege that I've experienced and that many on the inside are not privy to. So one of the things I recommend is to gauge where in the literacy process your loved one is, so that you can understand and maybe help them go through this grievance process, because it is lengthy and it does have to have certain parameters within a grievance. So I recommend that off the top. But of course, it has to have their name. Each individual must fill out the proper heading. And there you will have a box in there with a date on it. I always put it inside the body of the grievance as well, but I will get to that very shortly. So when you put all the heading dates in there, that does not suffice in and of itself to tell the story. In the grievance itself, there is a portion where you get to tell a narration of what exactly occurred, the incident that derives of the grievance. In there, I recommend as well that you put a name, time, and date. When utilizing time and date, I usually was in the practice of saying on this approximate time and approximate date, because again, the process is one in which you're dealing with. For the example, or with Mr. Allen just put forth, is you're on the yard, so you might not get a grievance for 3 or 4 days ahead of time, and then you start losing track of days when it's just monotonous in there. So always putting an approximate date and time, so that you don't nail yourself into a specific corner, and allow yourself a little bit of wiggle room for that lapse in judgment because of all these stressful factors. Again, Alan pointing forward the importance of facility being on the grievance. It's always important to be delineating where the incident occurred. A lot of the times when something happens, you get transferred from one facility to the next, and when you go to do your grievance, you try to go throughout the whole process, and therein lose the whole meat and potatoes of the grievance, because you lost them in how you got to where you were at, and that's neither here or there. Alan talked about how you can address that by strictly going to Springfield, and the whole purpose of that is because you want to address the facility in and of itself. So putting that in the body is super important, because it's where the action happened, right? And one of the next things is that it's super important that people always miss. I'm going to say about 70% of the times is your signature. There is a portion in the middle of the grievance form where you have to sign the grievance and check a box. And these are just reiterative processes that are set in place to deny you, right? Because you may have signed it, but you didn't check the box. And maybe there is not a date on this particular part of the grievance process or the grievance form, though it's been on the one that's on the letterhead. And again, going through and setting a date throughout the body of it is super important because it helps you get past these little hurdles that they set before you. Now, these are the things that are supposed to be in the grievance form. There are some, these are like the very basic. There are some that are a bit more extensive, and some that I highly recommend that you familiarize yourself with. Those who have loved ones on the inside can do so by going to the law library and just researching the Bill of Rights. Those are the bare bones rights that we have as incarcerated people or prisoners, as they're labeling us. And these rights will inform you on the very basic human rights you have, right? And there's freedom of the press, freedom of religion, and I can go down the line, but I think that's a tutorial for another time that maybe you can recommend. But another thing that you have to have within the body of the grievance is that you identify whoever is that's wronged you, that they have done so in their official capacity. So that means that when they're doing so, they're doing it as a officer, as a grievance officer, as a warden, because they have a funny way of skirting around just being responsible for anything. So nailing them down to their official capacity sometimes helps, sometimes doesn't, but more times than not, it will help. And the final thing that needs to be in the body of your grievance that I feel is super important is that they act with deliberate indifference. That means that they are knowledgeable of what is actually occurring, but are just being dismissive because they just really don't care. And those are terms that are going to be looked upon by the courts, because that is what they're trying to gauge, whether they're doing something because the Department of Corrections is overwhelmed, or if they're just doing it because they don't care. And that's what you have to prove. Unfortunately, that's a high hill to succumb, but it's one that we have to pass, and we have to start doing so from the beginning. Now I'm going to go into some of the little key points into what I feel grievances should have. Alan went through a good example of how things get lost in the shuffle of things. And what I recommend is a proof of service. I will provide one at the end of the training so that people are aware of what it looks like. All it is stating what you're serving, who you're serving, what the date, the location of the service, the type of service, and your name on there, either notarized or through penalty of perjury. And that you're just saying that I turned in these documents every leg of the way, so that you have it documented for yourself. And then turning the attention to copies. Copies are costly. Most of the time we don't have the ability to make copies ourselves, so we rely on family members and loved ones. And that's for peace of mind, knowing that it's going to get lost along the way. We have somebody on the outside willing to champion our cause. And it allows us to get through one of the major hurdles, which is access to things like this. Now, Alan talked about how important it is to document this and how ridiculous the process is. I'm gonna reiterate that point, that it's important because there are those of us on the outside who need this documentation so that we can move forward in making change for the folks on the inside. And we can't do that without people raising the alarm. So if it takes the time, and things may not change, but the process of change is slow. It took us this long to get here. It's going to take us twice as long to moving back to somewhere where it's humane, and it's important that we start documenting the way. And I'm going to turn it over. Thank you very much for the time.
Thank you so much, Pablo. Your firsthand experience cannot be replaced, so thank you very much. Our third panelist is Marshawn Allen. I will tell you a little bit about Marshawn. Before joining Represent Justice, Marshawn has been employed as a research and policy fellow with Fair and Just Prosecution and the policy director for the Restore Justice Foundation. Marshawn received a sentence of life without parole for his minor role in an offense that occurred when he was 15 years of age, but was released after almost 25 years because of the U.S. Supreme Court's decision in Miller versus Alabama. Since his release in 2016, Marshawn has become a staunch advocate for criminal justice reform and has received numerous awards and recognitions for his advocacy work. In 2018, the Illinois Judges Association presented Marshawn with the Recognition of Excellence in Outreach Award for participating in Your Future, Your Choice, a program designed to teach school-age children about aspects of the law that they often find themselves in conflict with. In 2019, Marshawn received the Liberty Bell Award from the Chicago Bar Association and the Grace Warren Award from the Campaign for Fair Sentencing of Youth. Marshawn currently serves on the board of directors for Restore Justice Foundation and the Campaign for Fair Sentencing of Youth, and is a member of the Incarcerated Children's Advocacy Network. In 2020, he was appointed by the governor of Illinois to the Juvenile Justice Commission. In 2006, Marshawn assisted the Illinois State Bar Association with a revision of post-trial remedies, a handbook for Illinois prisoners. He has earned certificates in paralegal studies, business management, computer technology, and restorative justice. He also holds an associate degree from Lakeland College, where he graduated summa cum laude, and a bachelor's degree in justice policy and advocacy from Northeastern Illinois. Take it away, Marshawn.
Thank you, Crisola. And I thank you, Alan and Pablo, for your contributions and the things you shared from your experiences as well. Good evening, everyone. I thank you all for joining us tonight. I just want to share some of my experiences when I was incarcerated with filing grievances. Alan and Pablo both gave you all some very good points about the grievance process and about writing grievances. And I have a few things I want to share from my own experience. And one of the things I want to point out is that, you know, make sure that the grievance you write is clearly explains the issue that you're writing about. Be thorough, but also keep it simple. There's not a lot of space on the grievance forms. You can use multiple forms if you need to, but that's where it comes into being thorough. You want to make sure you explain everything, but try not to be redundant or anything like that. I also recommend like keeping it to one topic a lot of times, or even to like related issues, because sometimes they won't respond to multiple issues in one grievance. They would just respond to one, and you could possibly be locked out of the process to file another grievance on those other issues because the time might have expired. Also, I wanted to point out that, like, in my experiences, some of the grievances that has been easier to win are those, and I'm saying easier, not a guaranteed win, because as Alan pointed out, that process where the counselor actually agreed and was supporting the inmates or the person's claim as grievance, and it was still denied. But those grievances that are usually easier to win or have a chance of winning are those that have evidence and support. And that evidence can be like documents such as like personal property receipts, commissary receipts, memorandums, any type of document that kind of helps support the claim. And to give you an example, for like a lost property claim, if say a person went to segregation and they received a inventory slip for the property being taken to personal property when they went to seg, and it lists all their items on there. And then when they get out of segregation, they have a slip that those items aren't on there when they return the property to them. And they can use those two forms to show like, hey, you know, when I went to segregation, this was on my inventory slip. And when I got out, it wasn't listed on here. That's one way you can prove it. Another way is when you have staff as witnesses, as Alan pointed out, the grievance, not the grievance officer, counsel agreeing with the person. That, as Alan pointed out, also that's not a guaranteed win. I actually had a case where a counselor agreed with me about the interpretation of the rule, and she recommended that my visiting privileges be restored in the grievance. But when it went to the grievance officer, they denied it. Then Springfield denied, and I ended up having to take it to court to end up getting my privileges back. Another one is, again, and there's a caveat, but I was thinking about there's a clear violation of the rules of policy. If you can point out in the rules that you're entitled to something and you're not getting it, or it was a procedure like doing a disciplinary procedure, they're supposed to call a witness and they didn't call your witnesses, and you can prove you requested the witnesses on your witness slip, what they provide to you. Those have a better chance of winning. I recommend like getting familiar with the rules. That procedure there require you or your loved one to be very familiar with the rules inside the institution. When I ever went to a new institution, I will read the inmate handbook from cover to cover just to understand what, because the rules change. There are different responsibilities and things like that, but I read the inmate handbook from cover to cover. And some of the grievances that are more difficult or impossible to win are theirs where there's no evidentiary support for it. And mostly staff misconduct grievances are like, I've never won a staff misconduct grievance ever. And I think it's partly because of the dynamic between the grievance officers and the officers there. They kind of rely on them for security and support. And it's very difficult for them to not file a grievance, but rule in a grievance that officer, their investigation revealed that an officer did some type of misconduct. I also think that those are also harder to prove because there's no documents to support it. Usually, if there are other prisoners or people, incarcerated people around, you can put them down as witnesses, but they don't take their words forward. The other officers usually don't agree with it, so they're very difficult to win. And as Pablo and Alan pointed out about keeping copies of the grievance and exhibits, I would recommend not sending your only copy. Again, handwrite a copy if possible. And I would try to hand my grievance to the counselor and not try to send it to the institution mail because it sometimes get lost. So I would try to hand it to the grievance officer, and I would recommend that. I will also recommend like following up after you file the grievances within the time frame if you can. If you send it through the institutional mail and you haven't heard anything back, I would say write the counselor and ask her, say, hey, did you get this grievance? And a lot of times, sometimes depending on the counselor, they will write back and say, yes, I got it, it's been filed. And then you keep that, and it could be a confirmation that you did file a grievance if you don't have any other way to prove it.
You got muted, Marshawn, sorry.
I'm sorry. The other thing I want to talk about is retaliation. I did have experience in prison where I filed a grievance and I was retaliated against by the officers. It is a real thing. It typically happens when you're filing grievances against staff misconduct, and they try to do that to deter you from doing it in the future. I refuse to allow them to do that to me. Some officers have retaliated against my cellmate and I because we filed grievances against them. It was a similar situation where Alan pointed out in the grievance where our cell was being shaken down. Officers just threw property away that they weren't supposed to. They were supposed to confiscate it if they thought it was contraband and put on a shakedown slip. And there was a process they're supposed to went through, and they didn't go through that process, just threw it away. And we filed grievances on it because we thought that if we don't say anything, they're going to keep doing it. And when the counselor contacted them about the grievance, the officers got upset about it, and they began retaliating against us by shaking down our cells more, refusing to let us take showers. They even wrote disciplinary reports against us, sent both of us to SAG for a significant period of time. But even then, knowing my rights, that them retaliating against me for filing grievance was a violation of my constitutional rights, and I ended up filing a lawsuit and winning a settlement for them violating my rights. So I would encourage, sometimes you have to weigh the benefits, is it worth it? But I was just in a position where I refused. That was the only way I can fight back, and I wasn't going to allow the officers to take that away from me. no matter what. So I fought and fought and fought, and I would recommend or hope that your loved one would do the same, but also to be cautious and to be aware that, you know, retaliation can happen, and just to take precautions about that. But that's all I have to share, and I would turn it back over to our host.
Well, thank you, Marshawn and Alan and Pablo. We do have some questions in the chat, and Alyssa is gonna be doing those questions for us. So if you have any more, we'll try to get to them.
Okay, so I'm gonna read them, and please, if I miss you, just flag it. And I am Restored Justice's communications manager if we haven't met. So I'm gonna start from the bottom and scroll back up. So Andrea, this is a great question. She asks, would keeping juvenile residents or youth residents locked down for longer than 24 hours straight be something worth that you could file a grievance over?
The answer to that question is should you file a grievance? In my opinion, is always yes. All I can do is deny it, and if you don't file, you can't challenge it later. As to whether it's a lawsuit, I think it depends on why they're locked down for more than 24 hours. If it's for disciplinary reasons, that violates, my understanding is that violates the current state law and probably the Constitution. If it's for COVID, however, to keep everybody safe, then you're going to have a much bigger challenge. But the answer to whether or not you should file a grievance is yes.
Like that.
Yeah, that's wonderful. So if someone is in a protected facility, Trudy is asking, is the grievance process the same?
And we had a little side chat on this. So it doesn't matter what they call a facility. The question is whether or not it's a prison, meaning whether or not you are there because you've been charged with or convicted of a crime. So if that is true, then yes, no matter if it's called a protective facility, if it's called a halfway house, as long as it's run by the Department of Corrections and your movements are restricted, then it's going to be a prison, and you have to file a grievance and go through that whole process. If you're not in prison, or you're in some sort of facility like you're civilly committed, for example, where you have not been convicted of a crime, but it's a civil commitment because you might be a danger to somebody, then you're not in a prison, and therefore you don't have to file the grievance.
Thank you. That's really helpful. I think I know the answer based on the last one, but should you file a grievance if your constitutional rights were violated?
Absolutely.
I expected that. And then Andrea, I hope I'm pronouncing this correctly, but I think we might need a tad bit more information, but you're asking, is the process the same for an incarcerated youth? Do you mean someone who's in an adult facility or someone in one of the juvenile justice facilities? I think we could start. Oh, I think you're typing. Well, maybe we start with what I think is if it's a youth in an adult facility.
There, the answer is yes, absolutely the same. If you're in the Illinois Department of Corrections, you have to follow the Illinois Department of Corrections rules, no matter how you got there. If you're in a juvenile facility, which I see is what Andrea was referring to, there is a grievance process, but it's not the same process. So again, just like whether you're in a county jail or in the federal system, you have to look at those facility rules. The rules that apply in the Department of Corrections no longer apply in juvenile. They used to be the same, but we split the juvenile system in Illinois separate from the adult prison system a decade or so ago. I don't remember the exact date. So now it has its own rules, and you got to follow those rules.
Okay, so a question for Marshawn and Pablo. Why do you think it's important for loved ones to know about grievances?
Yeah, I'm gonna jump in there because I also seen a question about if you can file on medical staff and other things of that nature. It's important that you document your stay within the Department of Corrections. There's a narrative that's getting pushed where they're saying that they're providing certain services, and we're not being given the bare minimum of these services. So documenting things to bring about change is important. Otherwise, all we have are the narratives that are being pushed by the correctional facility, and one of them is that, hey, guess what? Everything's cool here because nobody's filing grievances. So it's important to raise these issues, and again, use your voice. That's one of the only things that you have on the inside. When it comes to using your voice, it's important that you utilize that voice.
Thank you.
Thank you. And Marshawn, is there anything you want to add?
Yeah, I can add very briefly. I think that the why it is important for you to know, I mean, basically it's just so you can support your loved one who's there. First, your loved one may not know about the process, and you being aware of it you can inform him or her about it. But also if they need assistance, you can be aware of the time limits that Alan talked about, and even knowing that why your loved one may be sending you a grievance in the mail. To be copied and stuff like that. You come in here and understanding this to Alan, explain why. I think that would be very helpful, just to understand what the process is that your loved one is going through and how you can support them.
Thank you both. So Alan, a question, have there been attempts to try to end the catch-22 where there are no time limits on responses from the counselor? Alan, you're on mute.
Of course.
Sorry.
It had to happen at least once.
Sorry about that. Have there been attempts? Sure. I mean, we raise this all the time. Has anybody done anything about it? Absolutely not.
All right. I think we have one last question, right, Alyssa?
Yeah, so this is a question from Crystal. Can you file a grievance against medical staff, including a doctor?
Yes. If it happened inside prison, yes. And if it happened while you are a prisoner, even if it happened in an outside facility, yes.
And it's always important to put everybody who's been involved in the process. So if it's a doctor or warden, whoever you talk to, make sure that's documented.
Did you see the answer? Someone had asked if you can file a grievance on behalf of someone.
Yeah, you cannot file a grievance on behalf of somebody. We've had a situation where somebody was taken out there on a stretcher, right, unconscious, and we could not file a grievance on behalf of the individual, but we can file on kind of what we've seen going on around it. So there's a way to document it. Either way, it's going to get thrown out, but at least even still you have that situation documented, which is what's important.
And then I think this is our final question. If I missed anything, please chat really quickly. But Crystal asks as a follow-up, if there's a medical emergency, what would you suggest doing for your loved one, since probably the grievance process is too late there?
Phone calls. Yeah, one of the things we do is phone calls. Your local representatives, your aldermen, the ward, and everybody and anybody, and you make as much noise as possible.
I'm going to go further and say the director's staff and the governor's staff. If you really want to get them going, if people kept calling, they would realize the problems that do exist. When no one tells their legislators, then no one thinks there's any problem. They don't think there's problems. And we all know there's a lot to be done in the prison system.
And
I do want to add that, yes, the grievance is going to be too late, but you got to file one anyway, because if you don't get satisfaction, you do get injured, you still need to file one, even if it happened to.
Spoken like a true attorney. I love it.
And piggybacking on what we say and documenting, when you make these phone calls and these outreaches, record them, make sure they know that they're being recorded. And if their documentation, make sure you keep copies of that as well.
Okay.
Thank you.
Well-
I know we're at time, but really quickly, I know if you do need to go, but I want Pablo and Marshawn, I don't want to miss this question because I do think it is a good way to kind of close the evening. If you could just really briefly tell us why you think it's important for loved ones to know about grievances.
Okay,
Pablo?
so yeah, I guess I'll go
Marshawn?
first. It's important that you familiarize yourself with this process because when we're in there, it's already discouraging enough, right? We do need your support on the inside to overcome a lot of these hurdles, these catch-22s, where we're up against timelines and we're gonna be known as somebody who's nefarious and trying to get around the system. But when we have this outside voice, this outside system, it's not just for overcoming this, it's that sanity. This is our resistance to what is going on in there. And one of the things that we require for our sanity is this backbone, and you're it. So it's very important that you involve yourself in this process. And one way in doing so is learning the process and encouraging it, right? And so I highly recommend that.
Marshawn, do you have anything to add to that?
I do. As I mentioned earlier about just to do it to like support your loved one, to learn about the process so you can support your loved one. As again, like they may not know about the process. Some of your loved ones may not know about it, and you can inform them about this process. You can tell them about the things you learned here tonight. And, if they need assistance, anything like that, you can be able to walk them through the process or just support them with their efforts to file a grievance.
Thank you.
Thank you. And if anyone has additional questions that you think of, feel free to reach out to us and we will get back to you with that information. Also, if you are on social media, please follow Restore Justice and Coalition to Decarcerate Illinois. We will have additional events in the future, and just follow our work. We love having more supporters. So if you are not already, please follow us. But thank you, everyone. Thank you to the panelists, Alan, Pablo, Marshawn, really appreciate you. Thank you.
Yeah, and I wanted to thank everyone who came on that you do care about people who are in custody right now. And thank you, to both our interpreters and everyone. Have a great evening.